And as the 2004-64 revenue ruling indicates, if any creditor can access the assets in the trust, then it's going to be includable in your estate under Section 2036. And think about it this way. Let's say I did a trust, say here in Florida, for my own benefit, and I said, well, the only thing the trustee can give me money for is for groceries. Well, that means if I don't pay my grocer, he can go ahead and get it out. I can relegate him to the assets of the trust. Or it can only be for income taxes. Well, 2004-64 says that's sufficient to make it subject to your claims of creditors and to cause estate tax inclusion. So all the states that have these exceptions for spouses and for minor children, or even for the state itself, many of these states say, including Hawaii, including Utah, that the state, if you owe money to the state for taxes or any other reason, they can go to the assets of that trust. So I think the only two states are going to be Alaska and maybe Nevada, which seems to be very serious. Now, suppose I'm wrong. Suppose this ruling is wrong. Blattmachr is wrong, the IRS is wrong, and you become worried that there's going to be inclusion. What more can you do? One of the things that I recommend if you do a self-settled trust for yourself or your client, delay the time that you're eligible to receive distributions. One of the reasons is that if you have to wait a year or 2 or 3 or 4 years, they're going to have to say that the transfer to it is complete for gift tax purposes. And by the way, if you are married, you ought to provide that you are eligible to receive a distribution only at such time, if any, that you're not married to and living with another person as husband and wife. Because if you're happily married, you don't care if the distributions are going to your spouse or they're coming to you. If you get mad at your spouse because he or she isn't expending it the way you want, you leave. And your ability to leave and take your spouse out as a beneficiary is not a power to control the beneficial enjoyment. We know that because of Revenue Ruling 80-255. You might want to write it down. And a State of Tully Sr. basically saying those are acts of independent significance and they do not count for estate tax inclusion purposes. So you put in every trust, this grantor is eligible to receive distributions only at such time, if any, that the grantor is not married to and living with another person and his husband and wife. So if your client is married at the time she dies, then the section can't apply because she's not even eligible to receive a distribution. In addition, you ought to allow the grantor to be eliminated, expunged as a beneficiary of the trust. So I've done this self-settled trust, and I'm on the 6th green, and it's the first time in my life I'm going to get a par on a hole after 10,000 tries, and I'm just so excited. It's only a 6-inch putt, and I keel over with a heart attack. And my buddy picks up the phone, and he calls the trust protector and says, Jonathan's had a heart attack. We think by the time he gets to the hospital, they're going to declare him dead upon arrival. You better do something. And he then will be able to pull the trigger and eliminate me as a beneficiary. Don't let the trustee do it, because the trustee has a fiduciary duty, and the IRS might argue. Remember, the IRS is only in it for what? What is the IRS only in it for? The money! The money! So they're going to go, no, 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 the trustee couldn't do it because it violated the duty. So you're going to put in a trust protector or somebody else and say they have no fiduciary duty and they can expunge Jonathan or whoever the grantor is as a beneficiary of this trust. Now, if that happens just before I die, can 2036 or 2038 apply? You have 2 choices, yes or no. Think about what I'm trying to get to. Now, think about, don't try to analyze, just say, all right, Jonathan's trying to tell us this is a good deal. If I'm not a beneficiary at the moment of my death, can 2036 or 2030? No, it can't. Why? Because those sections take a snapshot at the moment of death. Was Jonathan a beneficiary or not? If the answer is no, those sections can't apply. But of course, we have to worry about section 2035. Because 2035 says if you have a 2036 or a 2037 or a 2038 interest and you transfer it within 3 years of your death, it comes back into your estate as though you still have the power of death. If I'm eliminated, David, as a beneficiary by somebody else, have I made a transfer? No. I don't think so. So as a consequence, you can structure these to be, I'm not going to tell you, there's nothing foolproof. There are no guarantees in the law. But if you have a client who is interested in transferring her $5 million but wants to be eligible to receive distributions back, an Alaska self-settled trust where she understands it is the last resort for her. Don't go to the trustee unless you've gotten rid of everything else. By the way, if she's gotten rid of everything else, even if it's going to be in her estate, it's probably not going to be a problem, but she can therefore get it back. Now, if you're married, it's even a better deal. It's an absolutely terrific deal. Here's what you're going to do. You're going to take $5 million, and you're going to create a trust for your wife, and your wife is going to take $5 million and create the trust for you. You didn't create the trust for your benefit. Your wife didn't create the trust for her benefit, so that seems to work, except what do we have to worry about? The reciprocal. Well, even in a second marriage situation, think about it, even in a second marriage situation, Diana and I get married. She has a child from her marriage, I have children from my marriage, she's got her $5 million, I've got mine. We may even have a prenup saying mine is mine and yours is yours, and that's the deal. But if I put $5 million in trust for Diana, and Diana puts $5 million in trust for me, have I lost anything? I don't think so. Has Diana lost anything? I don't think so. You've got to worry about the reciprocal trust doctrine. Now, that brings us to the famous case of estate of Levy. Mr. and Mrs. Levy lived in New Jersey. And on the same day, using the same property, which was a unique type of property, the assets in their closely held business, using the same lawyer and the same trustees, Mr. Levy created a trust for Mrs. Levy, giving her the income for life, and Mrs. Levy created a trust for Mr. Levy, giving him the income for life, and then Mr. Levy up and died. And the IRS said, after a state of grace, this is a layup. We can't lose. And it was a lot of money. But Mr. Levy's estate said, oh, IRS, you forgot to notice something. Mr. Levy gave Mrs. Levy a lifetime special power of appointment where she could direct the trustee to give the assets in the trust that he created to her to anybody in the world other than herself, her estate, her creditors, or the creditors of her estate. But Mrs. Levy didn't give Mrs. Levy any such power of appointment during lifetime. The IRS, in its briefs, conceded that if that power were valid under New Jersey law, which is where they lived, the reciprocal trust doctrine could not apply. The tax court found that the power was in fact a valid power under New Jersey law, and it therefore ruled that the trust was not includable in his estate. And that is one of the things that you will use. By the way, the IRS in private letter rulings since that time, that's a 1983 tax court memorandum decision, they went ahead and they've approved that. Now, let me tell you, you're going to do more. The first thing you're going to do is to use different standards for payment. The trust I create for Diana, for example, will provide that the trustee can give income and principal to Diana for any reason at all. But the trust that Diana creates for me is going to say you can only give it to Jonathan for his health, education, maintenance, and support. That kind of disparity alone probably is sufficient for the doctrine to prevent to be applied. Second is, in the trust that I create for Diana, I'm going to allow the trustee to convert Diana's discretionary income interest into a fixed 4% unitrust interest. But the trust she's going to create for me is going to prohibit the trustee from doing that with respect to me. Third, we're going to have a difference in powers of appointment, and I'm going to call it Levy Plus. Not only am I going to give Diana the same kind of broad lifetime special power that Mr. Levy gave Mrs. Levy, Diana's not going to give anyone to me, but we're each going to give each other testamentary powers, except the one that I give Diana, she can exercise alone to anybody in the world other than herself, her creditors, or the creditors of her estate, alone. And she can do it by will or by deed. But the one she gives me is only going to be by will, and it's only going to be to a class of descendants of her mother. And I will need the consent of a non-adverse party. An enormous difference, a true change in circumstance for Diana and me. So you're going to have a kind of a double Levy issue here. I call it Levy Plus. In addition, we're going to have different trustees. And what I'm going to do is I'm going to say Diana can remove and replace those trustees at any time she wants for any reason or no reason at all, as long as she doesn't put in herself or someone who's related or subordinate to her under the auspices of what revenue ruling? 95-58. 95-58. But Diana's not going to give me any power to remove whatsoever. She'll put in an independent person as trust protector. By the way, we're going to fund these with different properties, and we're going to do it at somewhat different times. You are going to prevent your clients, or if you do this for yourself, from being the low-hanging fruit. The IRS is only in it for the money, and they don't want to work hard to get it. They want the low-hanging fruit. Cases like estate of Strange. They're looking for the low-hanging fruit. So when they come to Diana and me, they've got a gargantuan problem. They're going to bypass us and go to another tree where the fruit is hanging lower. So these are the things that you can do, and you'll have a great time. Now, any unique upside or downside? In 2005, the Congress passed Section 548E of the U.S. Bankruptcy Code. And 548E says, if you create a self-settled trust or a similar arrangement, whatever a similar arrangement means, and if you go bankrupt within 10 years, the assets in that self-settled trust are included in your bankruptcy estate, which means that it's going to be distributed to your creditors if you created that trust to try to delay, defraud, or hinder a creditor. Now, when Diana and I created these trusts for each other, was our motive to hinder, delay, or defraud creditors? What was our purpose? Our purpose was to use this once-ever opportunity to transfer $5 million out of our estates. You will win that case. And now I've got to tell you about Mr. Mortensen. Mr. Mortensen was a professor in Alaska, and he had been living a wonderful life. He had a beautiful wife, he had great kids, doing just great. Something happened. I don't know whether it was a disease or an attitude, but over a very short period of time, he began to lose all his assets. He lost his job. He couldn't get a new job. His wife divorced him, and he had one asset left. He had a little tiny home in the town of Seldovia. By the way, Seldovia is a beautiful little town on the Alaska Peninsula, in the Kenai Peninsula. It's a beautiful little one. And he created a self-settled trust. Home was worth about 80 grand. And he put it in the trust, and the next year he went bankruptcy. Now, it was a self-settled trust, so that part of 548E was covered. He had done it within 10 years, so that was covered. The question was he trying to delay, defraud, or hinder a creditor? Now, when you look at his financial circumstance and how precarious it was at the time that he died, and this was his last asset, it looks bad, but the court said, I don't even have to look that hard, because in the recital of the purposes of the trust that he wrote for himself, and he was not a lawyer, it said, I am doing this to protect this home from the claims of my creditors. Okay? He shot himself in the foot. So you will see now estate of Mortensen. It is no big deal, but a couple of lessons out of it. Number one, do your self-settled trust if you want asset protection before you have a creditor problem. And number two, establish a completely independent, non-creditor reason, like getting the assets out of your estate. I'm going to tell you, everybody in this room should do this, whether you're married or not, and not 1 in 10 of you will. And someday, I promise, you'll come back, Laird, you're going to come back and say, you know, John and I probably should have done this. But you won't. And I can't tell you why, except you're going to say it's not my problem. But if you ever think you might have a creditor problem, you're now really doing something wonderful for yourself as well. And everybody here who's practices law, you've got to understand, probably at least once in your career, you will be sued for malpractice. And having had it happen to me, even though I successfully defended it, it is a very uncomfortable thing to go through.